The Subcommittee on Elections of the Committee on House Administration will now come to order. I'm pleased that several members have joined us today, and I will recognize each one of them by name. First of all, to say greetings to each one of them, but also to establish a quorum. We have with us Mr. Aguilar from California, the ranking member, Mr. Stile from Wisconsin, Ms. Ledger Fernandez from New Mexico, the ranking member of the full committee, Mr. Davis of Illinois, Ms. Scanlon from Pennsylvania, and of course, myself. I will declare a quorum to be present. Let me begin by saying good afternoon to all of you. As we begin today, I want to note that we are holding this hearing in compliance with the regulations for remote committee proceedings pursuant to House Resolution 8. Generally, we ask committee members and witnesses to keep their microphones muted when not speaking to limit background noise. Members will need to unmute themselves when seeking recognition or when recognized for their 5 minutes. Witnesses will also need to unmute themselves when recognized for their 5 minutes or when answering a question. Now, members and witnesses, please keep your cameras on at all times. Even if you need to step away for just a few moments, please do not leave the meeting or turn your camera off. There are good reasons for this rule, and I will insist that we abide by the rule. I would also like to remind members that the regulations governing remote proceedings require that we cannot participate in more than one committee proceeding at the same time. And so at this time, I will ask unanimous consent that all members have 5 legislative days in which to revise and extend their remarks and have any written statements be made part of the record. I hear no objections. Hearing no objections, it is so ordered. Ladies and gentlemen, this is the second in a series of hearings this subcommittee will be conducting this calendar year, examining voting and election administration in the United States of America. Today, we are examining state and local laws and processes governing the removal of registered voters from voting rolls. Federal law requires that states make a reasonable effort. That's the terminology in the law. States must make a reasonable effort to remove registered voters from their rolls who are ineligible to vote in the state because, for example, they have passed away, they've died, or moved maybe to another state. But the law also requires that any state statute or any process governing the removal of voters from the voting rolls must be uniform, must be non-discriminatory, and in compliance with the 1965 Voting Rights Act. Now, since the Supreme Court's 2013 decision in Shelby County versus Holder, which we are all familiar with, that case rendered a key provision of the Voting Rights Act to be inoperable. A number of states across the country have moved to aggressively remove voters from their voting rolls. Recent reports have found that states removed more than 30 million voters from their rolls between 2014 and 2018, just a span of 4 years. The voter roll purges have been particularly aggressive in states that before Shelby had to obtain pre-clearance under the Voting Rights Act of their voter removal programs from the Department of Justice. One study that I've read, one study found post-Shelby County increases in purge rates of between 1.5 and 4.5 points in states and localities formerly covered by the Voting Rights Act compared to states and localities that had never been covered. That causes me some concern. Far too often, these new aggressive voter roll purge efforts have wrongfully removed voters who were properly registered to vote. Indeed, studies indicate that hundreds of thousands of properly registered voters have been the subject of flawed voter purge efforts. Voters and organizations have spent thousands of hours and millions of dollars to correct these errors. And so I think we can do better. We must do better. We should be doing all that is in our power to make it easier to vote, not erroneously trying to strip properly registered voters of their right to vote. The facts and circumstances surrounding several of the voter purges also raise significant questions about whether those voter purge efforts complied with mandates under federal law, that any program providing for the removal of voters from voting lists, they must be uniform and they must be non-discriminatory. Several states have engaged in highly public efforts to remove non-citizens from their voting rolls. These efforts, which disproportionately seek to disenfranchise Hispanic and Latino voters, often rely on databases that are known to have inaccurate citizenship information. Equally troubling is evidence that the databases and processes many states are using to remove voters from their rolls are likely to disproportionately burden minority voters. Let me put it simply. Long-standing socioeconomic disparities appear to make it more likely that properly registered minority voters are erroneously identified as subjects for removal. That troubles me, and it should trouble you. Also troubling is a growing trend of conservative interest groups filing legal actions seeking to compel states and compel localities to remove voters from their rolls. Many of these actions, which rely on little more than allegations that registration rates are implausibly high, have been targeted. They've been targeted at cities and counties with disproportionately large minority populations. High voter registration should be a subject of community pride, not an invitation to litigate. And perhaps most troubling is the raft of bills recently enacted or currently being considered by state legislatures to remove even more voters from the rolls. These bills which have their genesis in the baseless allegations of irregularities in the 2020 election, often provide for the removal of voters based on little more than a voter exercising his or her right not to vote in a single election. The testimony provided today will help us as this committee seeks to understand what needs to be done to ensure that voter list maintenance efforts are non-discriminatory and do not erroneously remove properly registered voters, plain and simple. And so I look forward to hearing from today's witnesses and working with my colleagues on this very, very important issue. I now would like to recognize the ranking member of the subcommittee, Mr. Stile, for his opening statement. Mr. Stile?
Thank you very much, Chairman. I can report in the state of Wisconsin, we have a lot of pride because we have one of the highest voter participation rates in the country. But as we dive into this topic, federal law requires states to, quote, conduct a general program that makes a reasonable effort to remove from the official list any voters ineligible by reason of death or change of address. And so when President Clinton signed the National Voter Registration Act in 1993, he said, quote, every year from now on, we're going to have more registered voters and more people voting. We're going to make the system work, end quote. And the NVRA's purpose is to make it easier to register to vote and to ensure that states have accurate voter rolls to support voter confidence in federal elections. That's what the Democrat House, Senate, and Democratic President Bill Clinton thought then. Now Democrats suggest that this Democrat-led effort interferes with free and fair access to the ballots. Is this the same Democratic Party that supported the NVRA's reasonable safeguards in 1993? There's nothing that should be controversial about ensuring people who have died or moved away aren't registered at their old address. The state's refusal to comply with NVRA is expensive, it's wasteful, it creates voter confusion, and it weakens voter confidence in election results. If we want to actually increase voter participation, I believe we should be fighting for better run elections so people will hold confidence in the election results. If states live mail ballots to everyone on an outdated list, we might expect multiple ballots to arrive at incorrect addresses. Many of these problems wouldn't happen with proper list maintenance. Outdated voter rolls may lead to long lines for in-person voting. In 2020, LA County voters waited hours because voter check equipment was overwhelmed. Turns out LA County had over 1.5 million ineligible people on the voter rolls. A suit was filed by a nonpartisan watchdog that alleged LA County had 112% of adults citizens registered to vote. Under pressure, as you may know, California and LA County finally agreed to clean up their voter rolls in 2019. And unfortunately, then California Secretary of State, Alex Padilla, could not tell this committee last fall how many ineligible people, those who were deceased or those who moved out of the state, had been removed from California's unmaintained voter rolls. Not a lot of faith that California is in compliance with the NVRA. Pennsylvania recently was forced to comply with federal law and remove 21,000 deceased individuals. Michigan, their Secretary of State removed 177,000 ineligible, saying that Michigan was not engaged in sufficient comprehensive efforts to maintain its lists. In my home state of Wisconsin, there was a lawsuit recently on this issue of list maintenance. Wisconsin wasn't keeping its voter list up to date, and over 70,000 individuals are registered, even though by all indications they have moved. My state's attorney general, a witness we'll hear from today, filed a brief and presented oral arguments in court in support of keeping these individuals on Wisconsin voter rolls, even though they no longer lived where they were registered. And according to WEC, none of them voted in 2020, further indicating that these individuals moved. But across the board, not that these facts are stopping Democrats from trying to conflate the issue. Speaker Pelosi tweeted about the case and got a pants on fire rating from PolitiFact because she claimed 200,000 plus people, quote, would be prohibited from voting, end quote. Of course, that's not true. Anyone who is moved may register to vote with a new address. And in Wisconsin, folks can even register to vote at the polls on election day. The point is this: our goal should always be to ensure every eligible voter can cast their vote and that each voter has confidence in the integrity of our election process and outcomes. The NVRA provides specific instructions for conducting list maintenance and voter fail-safes. No voter may be removed solely for failure to vote, no matter how long that's been. No comprehensive list maintenance may be conducted within 90 days of a federal election. And importantly, if a mistake is made, voters can still preserve their vote by casting a provisional ballot and addressing the issue with election officials. Inaccurate voter lists can significantly increase wait times for in-person voting, and have ineligible voters on the voter rolls weakens voter confidence that our elections are run fairly and are run accurately. I believe we should be working to ensure states comply with federal law Democrats passed in 1993, not making excuses. But across the board, I look forward to today's discussion and conversation. And with that, Mr. Chairman, I will yield back.
Thank you, Mr. Stahl. The gentleman yields back. In just a moment, I will introduce today's panel. But before I do that, let me just acknowledge the presence of the full committee chair, Ms. Loughran of California, and yield time to her for such statements that she may choose to make. Ms. Loughran, thank you for joining us.
Thank you so much, Mr. Chairman. I just wanted to stop by for a minute and thank the members of the Election Subcommittee for the vigor with which they are approaching the questions of the right to vote in America, and thank also our witnesses for appearing today. Obviously, voting is fundamental for American citizens. It is the whole basis for our country's freedom and what our brave men and women have gone off to fight for over the decades so that we have that precious right. We need to guard that right. And I am confident that the committee's inquiries will help protect that right. We all know that the NVRA was passed when the Voting Rights Act was in full swing before the Shelby decision. And so here's the question. Have there been pretextual uses of purges that really are intended to get to the essence of what the Voting Rights Act was originally intended to protect? I think that the committee's deep dive, the data that you will get, will inform the Congress and the country as to what steps, if any, we should take relative to the Voting Rights Act and the preservation of the rights of every single American citizen to vote. So with that, Mr. Chairman, I thank you for letting me sit in and listen and share these words. I commend you for your excellent leadership and every member of this committee for the work that you're doing, and I yield back with gratitude.
Thank you, Madam Chair, and thank you so very much for your leadership and all that you do, not just for this committee, but for the Congress. Thank you very much. Let me also extend an opportunity to the ranking member of the full committee, my dear, dear friend and neighbor from the great state of Illinois, Mr. Davis, for any remarks that he might want to make before we hear from the witnesses.
Mr. Chair, I'm probably going to surprise you, the chairperson, and the rest of my colleagues today by deciding not to go on a diatribe. And I want to hear from our guest today, and I'd like to get as quickly into the Q&A as we possibly can. And don't think this will probably ever happen again in our career together. I am going to yield back the balance of my time.
Well, you're very kind, Mr. Davis. We will allow you to accumulate these minutes. How about that? As a reminder to our witnesses, each of you will be recognized for 5 minutes. There is a timer on your screen. I think you can see it there to the left. There's a timer on your screen. Please be sure you can see the timer and are mindful of the 5-minute time limit. Your entire written statements will be made part of the record, and the record will remain open for at least 5 days for additional materials to be submitted. And so today I welcome each of our witnesses. Joining us today are Josh Call, who is the Attorney General for the state of Wisconsin. We have Sophia Lynn Lacken of the American Civil Liberties Union. We also have Dr. Mark Meredith of the University of Pennsylvania, and Kaylin Phillips of the Public Interest Legal Foundation. Let me be specific about each one. Josh Call is the 45th Attorney General of the state of Wisconsin, having grown up in Oshkosh and Fond du Lac, Wisconsin. General Call, I keep wanting to call it differently, but Call is the state's chief legal officer and is responsible for representing the state in all legal matters. General Call's top priorities are protecting public safety, fighting for clean and safe drinking water, and against climate change, and protecting the rights of Wisconsinites. Prior to serving as Attorney General, he litigated numerous cases under the 1965 Voting Rights Act, including Wisconsin, my home state of North Carolina, Ohio, and Virginia. He also served as federal prosecutor in Baltimore, Maryland. Next witness, Sophia Lynn Lacken. Lacken is the Deputy Director of the ACLU's Voting Rights Project and assisted in the planning, strategy, and supervision of the ACLU's voting rights litigation nationwide. She has an active docket protecting voting rights and combating voter suppression across the country, and has led or worked on successful challenges to discriminatory voting laws in several states, including Georgia, Indiana, Kansas, Missouri, North Carolina, Pennsylvania, Texas, and Virginia. Among other notable cases, she was lead counsel in cases successfully challenging a series of Indiana voter purge statutes. She is a frequent commentator on voting rights issues, presenting at conferences and conducting voting rights trainings nationwide. Next is Dr. Mark Meredith. Mark is an associate professor with the University of Pennsylvania Department of Political Science. His research examines the political economy of American elections with a particular focus on the application of causal inference methods. His substantive research interests include election administration, election law, political campaigns, and voter decision making. His research has been published in numerous leading journals, including the American Political Science Review, the American Journal of Political Science, the Journal of Politics, the Quarterly Journal of Political Science, and the Proceedings of the National Academies of Science. Kaylin Phillips. Kaylin is a litigation counsel with the Public Interest Legal Foundation. Ms. Phillips has extensive experience at every level of litigation in state and federal court, including our U.S. Supreme Court. She also has experience representing clients before federal and state administrative agencies. Before joining the Public Interest Legal Foundation, she was an associate at the BOP law firm, I guess I'm pronouncing that right, BOPP, the BOP law firm, where her federal practice focused on election law. Ms. Phillips has also authored numerous amicus curiae briefs on key election law issues such as one person, one vote. I now would like to recognize each one of our witnesses, and I will do them one at a time, starting with General Call. You are now recognized for 5 minutes.
Thank you to the chair and ranking member of the subcommittee, the chair and ranking member of the full committee, and also to the other members of Congress who are here. I'd like to start today by talking about Wisconsin's experience with ERIC data. Pursuant to legislation passed in 2015, the state of Wisconsin joined the Electronic Registration Information Center, Inc., which is known as ERIC. Through ERIC, states and the District of Columbia share data with the goal of using that data to assist them in identifying eligible voters who aren't registered and voter registrations that are no longer valid. ERIC uses data from states' voter files as well as data from other sources such as the U.S. Postal Service. Now, in 2017, Wisconsin for the first time received a so-called ERIC Movers Report, a report that identifies people who possibly have moved. That data has been received every other year, so we also received it in 2019. Based on the 2017 data, Wisconsin sent approximately 340,000 potential movers postcards, and it gave them 30 days to respond in order for them to remain active on the voter rolls. Over 6,000 voters responded and kept their voter registrations active at the address at which they were registered. The other voters who received those postcards were deactivated. Now, according to a memo from the staff at the Wisconsin Elections Commission, that's our body that oversees, our statewide body that oversees elections in Wisconsin, that deactivation created some problems in the 2018 spring primary. And according to the Election Commission memo, there were some voters who had not moved but hadn't returned their postcards who were left off the poll books. So the Wisconsin Election Commission followed up with some of the affected voters. And overall, based on their follow-ups and having identified situations where voters appeared to have moved but didn't, they reactivated over 12,000 voters to the rolls between January and March of 2018. In addition to that, there are 3 municipalities, the city of Milwaukee, the city of Green Bay, and the village of Hobart, that reached out and had their voters reactivated. So ultimately, what the Elections Commission did was create a supplemental movers poll list so that when voters showed up at the polls, they could confirm that they had not in fact moved and could thereby avoid re-registering. And over time, more than 6,000 voters ultimately re-registered that way. In 2019, the Election Commission used a different approach with the movers data it received. There, it sent out letters in October of 2019 to approximately 230,000 people and asked them to confirm that they still resided at their registration address. The letters indicated that voting would keep those voters active, and they didn't say anything about deactivating voters. The next month, however, in November 2019, a group known as WIL, the Wisconsin Institute for Law and Liberty, filed suit on behalf of 3 registered voters and taxpayers in Wisconsin, arguing that the voters who hadn't responded to those notices within 30 days should be deactivated. They made an argument under Wisconsin state law that deactivation was warranted. Initially, a circuit court judge granted their request and issued an order requiring the Election Commission to to comply with the provisions of state law, in its words, and deactivate the registrations of the electors who had failed to apply for continuation of their registration within 30 days of the date the notice was mailed under that provision. That decision was subsequently reversed in a 3-0 Court of Appeals decision. And the case then went up to our state Supreme Court. And as Ranking Member Stile mentioned, I personally argued that case before our state Supreme Court. Our court is generally regarded as having a 4-3 conservative majority. But despite that, the court ruled 5-2 to affirm the Court of Appeals decision that those voters did not need to be deactivated. So there are a couple points I'll just note briefly in my closing seconds. One is there were thousands of voters who were identified in the movers data who ultimately either responded to the mailing or reactivated their registrations at the polls. That comparison to the number of in-person voter fraud cases is dramatic. I see that my time is up.
All right, the gentleman's time has expired. Ms. Lakin, you are now recognized for 5 minutes.
Chair Butterfield, Ranking Member Stile, and members of the subcommittee and the full committee, thank you for the opportunity to testify today. My name is Sophia Lakin, and I am the Deputy Director of the ACLU Voting Rights Project. Everyone agrees that voter list maintenance, when done responsibly, is appropriate and necessary. But proper list maintenance entails not only removing ineligible registrants, but also taking care that eligible voters are not erroneously purged. Unfortunately, states and counties around the country have engaged in overzealous, sloppy, and/or poorly timed purge practices that have wrongly removed and ultimately disenfranchised eligible voters. Examples of court challenges to improper purges are described in my written testimony, but I'd like to highlight just a few here today. Proponents of more aggressive purging often propose targeting ineligible voters for removal by comparing state voter roll lists to various databases, like other states' voter registration lists. But these databases are often incomplete or out of date, and the protocols used to identify potential ineligible voters deeply flawed. As a result, eligible voters are often improperly flagged for purging, and the results of these distorted comparisons are frequently used irresponsibly to support false or exaggerated assertions about the integrity of our voter rolls. Texas provides a prime example. In 2019, Texas Attorney General Ken Paxton tweeted in capital letters, "Voter fraud alert," claiming that almost 100,000 registrants in Texas were non-citizens based on a voter roll comparison to driver's license records. But that was false. Within a week, it was clear that many of these voters were actually naturalized citizens who had already confirmed their citizenship. In Harris County alone, this translated to about 18,000 of the 30,000 voters flagged there. And an audit of 150 randomly chosen names from the remaining 12,000 revealed no non-citizens. The impact of this purge on naturalized citizens was of profound concern, not least because over 80% of Texas's naturalized citizens are Black or of Latino or Asian origin. Civil rights organizations, including the ACLU, sued, and the case was settled with Texas ending this deeply flawed effort. But the settlement came only after the court found that Texas, quote, created a mess, which, quote, exemplified the power of the government to strike fear and intimidate the least powerful among us. Texas taxpayers ended up on the hook for $450,000 in costs and attorney's fees. The potential for disenfranchisement as a result of these inaccurate purges is real. Too frequently, voters discover they're no longer on the rolls only when they show up at the polls, and it's too late to fix the error. This was the case with our Ohio client, Navy veteran Larry Harmon, who voted in the 2008 election, but like millions of Americans around the country, opted not to vote in the 2010 midterms. When Mr. Harmon tried to vote in the 2015 Ohio state elections, he arrived at the polls only to discover that his registration had been canceled, even though he had continuously lived and filed taxes at the same address for 17 years. Litigation is not adequate on its own to prevent disenfranchisement. These cases are costly and slow, and even if one practice is blocked, another can spring up in its place. Take Indiana. In 2017, Indiana adopted a purge program that required the immediate purge of voters flagged as having moved out of state using the highly inaccurate and now defunct interstate voter registration crosscheck program. Studies have shown that the crosscheck system incorrectly flagged people more than 99% of the time. But under the Indiana program, targeted voters would get no notice or opportunity to correct the record before they were removed. When it comes to accurate rolls, ensuring that voters have adequate notice and sufficient time to correct the record if they're wrongly purged is critical. Federal courts blocked the state from implementing the new requirement, but just a few months later, Indiana enacted a new law with the very same problem. Even the demise of crosscheck was not a deterrent. Indiana just created its own version, the Indiana Data Enhancement Association. This latest iteration of Indiana's purge program was again blocked, but Indiana appealed the ruling, and the appeal was argued this past April, nearly 4 years after the case was first brought. The United States continues to lag behind other developed democracies when it comes to voter participation in our elections. We should be working together to increase this participation and remove obstacles, including practices that wrongly remove voters. Thank you.
Thank you, Ms. Lakin. At this time, I'll recognize Dr. Meredith. You're recognized for 5 minutes.
Chairman Butterfield, Ranking Member Style, and members of the committee, thank you for the opportunity to testify before you today. Managing voter registrations or list maintenance is one of the most challenging tasks election administrators face. The structure of American election administration means that elections officials often are deciding whether to take actions to cancel a registration with uncertainty about whether a registrant remains eligible to vote at their address of registration. There are negative consequences both in failing to take action on the registrations of those who are no longer eligible to vote and when taking action on those registrations who are in fact eligible. Keeping ineligible registrations on the rolls increases the cost of election administration and leaves open the possibility that an invalid vote could be cast. Conversely, taking action on eligible registrations can reduce these registrants' trust in the electoral system and prevent them from casting a ballot. My testimony today highlights my research showing that poorly conceived list maintenance protocols can jeopardize electoral integrity by impeding eligible registrants, and particularly eligible minority registrants, from voting. Election administrators have not always recognized some limitations of the data commonly used in list maintenance protocols. List maintenance protocols often rely on information about registrants contained in other administrative data, including data from other states' registration rolls, to identify ineligible registrations. Sometimes information about a different individual, who I refer to as a registration doppelganger, gets attributed to a registrant. This occurred frequently, for example, in data provided by the Interstate Voter Registration Crosscheck Program, or Crosscheck, a consortium in operation between 2005 and 2019 to assist member states in identifying registrants who have moved out of state. Crosscheck identified cases in which a registrant in one member state shared the same first name, last name, and date of birth as a registrant in another member state. In some cases, election administrators took action on the registrations identified by Crosscheck, even in the absence of corroborating information indicating that these two registrations belong to the same person. While the probability that any two distinct registrants share the same first name, last name, and date of birth is exceedingly small, this happens with significant frequency once you are considering trillions of pairings of registrations. Thus, list maintenance protocols that took action on the basis of cross-check data in the absence of corroborating information made it harder for some eligible registrants to vote just because they had the misfortune of sharing the same first name, last name, and date of birth with a registrant in another cross-check member state. A study that I recently published about Wisconsin's list maintenance protocols in 2017 and 2018 illustrates other issues with using databases to identify registrants for cancellation without appropriate safeguards. In late 2017, the Wisconsin Elections Commission mailed out postcards to registrants flagged as potentially having moved by the Electronic Registration Information Center, or ERIC. The postcards asked recipients to confirm their registration to avoid having it canceled. Two findings of my study are particularly relevant. First, a majority of registrants who were eligible to vote at their address of registration failed to respond to the postcard. This highlights that giving notice is not sufficient to undo all of the damage when eligible registrations are canceled. Second, minority registrants were about twice as likely as white registrants to vote in 2018 at the address at which they were flagged as potentially moving from. This highlights the potential for new list maintenance protocols to particularly impede eligible minority registrants from voting when they're first enacted. The National Voter Registration Act of 1993, or NVRA, helps, but is not sufficient to prevent poorly conceived list maintenance protocols from unnecessarily disenfranchising voters. First, litigation relying on NVRA only blocked a recent Indiana law, which attempted to cancel registration solely on the basis of cross-check data once it had already been passed. Second, the NVRA does not stop Indiana or any other state from using flawed data like cross-check to move registrants from active to inactive status. There are a number of reasons why it can be more difficult for an inactive registrant to vote than an active registrant. For example, inactive registrants are excluded in many states from receiving certain forms of election mail that are shown to increase turnout. Finally, the NVRA does not cover all states. List maintenance protocols that lack meaningful safeguards, like Indiana's implementation of cross-check, come at a significant, perhaps unacceptable cost to electoral integrity. My research shows that applying a list maintenance protocol proposed by cross-check in Iowa would have flagged thousands of registrations that were in fact used to legally vote. Greater oversight could prevent the use of list maintenance protocols that fail to recognize that electoral integrity means ensuring eligible registrants can vote, as well as stopping ineligible votes from being cast. Thank you.
Thank you, Dr. Meredith. Ms. Phillips, you are now recognized for 5 minutes.
Chairman Butterfield, Ranking Member Style, members of the committee, thank you for the invitation to testify today. I am litigation counsel for the Public Interest Legal Foundation, a nonpartisan charity devoted to promoting election integrity and best practices for election officials. A significant problem facing Americans' electoral process is the chronic inaccuracy and lack of integrity in the voter rolls that list the individuals registered to vote in local, state, and federal elections. As an initial matter, I implore the committee to reconsider the use of the term purge when referring to list maintenance practices. Historically speaking, purges are often violent, systemic acts of removing political, racial, or ethnic groups from society. Simply put, list maintenance is good public policy. For example, the Public Interest Legal Foundation discovered one Pennsylvania registrant that had 7 active registrations. The failure to maintain a continuous program of reasonable list maintenance causes many problems, including inaccurate voter rolls and misallocation of election resources and funds by both election officials and candidates. The Public Interest Legal Foundation has developed a robust data analysis program with particular emphasis on voter registration list maintenance audit functions. In essence, the foundation can see how well of a job states are doing to identify and timely remove registrants who are deceased, relocated, exist in duplicate or worse, and may be claiming improper addresses as residences. The foundation recently settled a federal lawsuit against the Pennsylvania Department of State focused on the question of whether the Commonwealth was performing reasonable efforts to remove deceased registrants from the rolls per Section 8 of the National Voter Registration Act of 1993. Foundation researchers found in excess of 21,000 registered voters positively matched against verifiable death records, some with dates of death dating back as far as the late 1990s. In the aftermath of the 2020 election, lawmakers must come to understand the overall quality of an election experience, relying heavily on mail ballots, rests on the reliability of the voter registration lists. Vote by mail plus inaccurate registration lists equals problems. By expanding the removal categories under the National Voter Registration Act, we can reap the benefit of more detailed accounting practices and hedge the risk of a single person being automatically mailed 2 ballots with variations of their own names on it. In closing, we have seen marked improvement in voter roll quality over the past decade. Many states are showing noteworthy innovations in maintaining lists despite federal mandates based on practices and technologies from nearly 30 years ago. Congress can act to help identify and spread those best practices. The time for measured action is now. Election integrity policies have sustained popularity for years and are showing renewed spike in interest. I look forward to any further questions. Thank you for the opportunity to appear.
And thank you, Ms. Phillips, for your testimony. It is now time for member questions. I will go in the following order. Mr. Aguilar, you should go first.
Thank you so much, Mr. Chairman. Appreciate you having this hearing and Chairwoman Lofgren, Ranking Member Stile, and Ranking Member Davis for being here, and all of our witnesses who took the time to be here. Thank you so much. You know, we heard a lot here about voter list maintenance and how it can hurt Americans' ability to vote. Dr. Meredith, Ms. Lakin, and Attorney General Call, can each of you provide just one way that list maintenance can occur without removing Americans' access to the ballot box? Dr. Meredith?
I'll soon go first because I was named first. I think there are ways that you can improve the process to reduce the likelihood of errors in either direction. Whenever there's uncertainty, you can never be sure you're going to hit one way or another. But so your goal is to do the best that you can to reduce your errors. Your goal can never be zero errors. So I think one piece of data that is very helpful when in voter registration databases is the last 4 digits of an individual social security number. In cases where you have access to the last, in the case where both states have access to the last 4 digits of someone's social security number, both states do, they can make much more accurate assessments when they observe someone with the same first name, last name, and date of birth in their registration files to know whether those are the same person or these so-called registration doppelgangers.
Ms. Lakin?
There are, I think, a number of ways that voter list maintenance can be improved. One example I would give is perhaps automatic voter registration, which is a way of both facilitating participation and also making sure that voter rolls are more accurate by creating a constant stream of updates between registration agencies, other state agencies, and elections officials. About 19 states, including Representative Davis's home state of Illinois, have in recent years adopted these kinds of forms of automatic voter registration, which ensures that when voters move, for example, their registrations are automatically updated with the state. I think this is one really good way of ensuring both the accuracy of the voter rolls and ensuring that, or at the very least, reducing the risk that voters are improperly removed from the rolls.
Thank you. General Call?
Yeah, you know, there are very useful ways to utilize cross-state data like the ERIC data that I was talking about before. One of the purposes of that data is to encourage states to reach out to people who aren't registered and to help them get registered to vote. At the same time, that data can also be helpful in providing information to election administrators to identify cases where there might potentially be voters who should be deactivated. What's important, I think, though, is not to just take that data and act based on that data alone, but rather to follow up. And for example, if you believe that somebody who's registered may have died, to follow up and get confirmation from vital records as to what that data indicates may be the case.
Thank you. I appreciate the answer. Ms. Phillips, in 2016 and 2017, Public Interest Legal Foundation prepared a report titled Alien Invasion that alleged widespread non-citizen registration in Pennsylvania and Virginia and included highly sensitive personal information of numerous voters. Is that correct?
I disagree with the classification, but there is a report that we published called Alien Invasion, yes.
The report was found to include inaccuracies. Many of the voters listed in the report were, in fact, citizens properly registered to vote. Is that correct?
The report relied upon data from the state of Virginia. And if there was any problem with that data, that would lie in the hands of the state of Virginia. And in fact, we sued the state of Virginia for improper list maintenance.
Was the president and general counsel of your organization ever required to issue a written apology to voters that had incorrectly been described in the reports as non-citizens?
I know there is an apology. He made an apology.
Was he required to issue the apology?
Not to my
Yes.
knowledge.
Your organization has brought numerous efforts to try and force states and local governments to remove voters from their voting rolls. And given that your organization has been proven to not accurately determine whether voters are properly registered, why is your organization in a better position than local elected officials to decide which voters should be removed?
Well, I'd like to know what inaccuracies you've discovered. In fact, we've offered a bounty, so to speak, for anyone who can find somebody who was improperly removed resulting from our enforcement actions. And to date, no one has come forward saying that they were improperly removed as a result of our actions.
Thank you, Mr. Chairman. My time's up.
Thank you, Mr. Aguilar. This time I will recognize the ranking member, Mr. Stile, for 5 minutes.
Thank you, Mr. Chairman. What I'm hearing today is I think we can all agree we want every eligible voter to be able to cast a ballot. My objective is to ensure that it's easy to vote and hard to cheat. There's two key reasons why a person registered in a jurisdiction would need to be removed from the voter roll. The person is either deceased or the person has moved out of the jurisdiction or is otherwise disqualified. And federal law requires removing these registrants. In general, in Wisconsin, we do a pretty good job removing, in particular, deceased persons from the voter rolls. But at times, and in particular, when the death is closely timed to the election, there's been instances of a person voting illegally on behalf of a dead person. Mr. Call, are you familiar with the case of voter fraud in Ozaukee County from 2020, in which a Wisconsin woman was charged with voting on behalf of her dead partner?
I've read reporting about that, yes.
Very good. I think it's a case worthwhile looking into because I think it shows that there are instances when voter rolls are not clean, someone may try to take advantage of the situation. I think it shows the importance of making sure the voter rolls are accurate and up to date. And it's much more difficult, admittedly, to clean up voter rolls when someone moves because there's less paperwork associated than when someone has passed away. And the question before us today is how do we clean up and remove ineligible voters from our voter rolls to avoid any illegal votes while still making it easy for folks to vote legally. And so, Mr. Call, if I can, should election officials in Wisconsin be prioritizing maintaining accurate voter rolls, in your opinion?
Yes, I think list maintenance is important for all the reasons that you've heard spoken about today. And I also think in Wisconsin, we have same-day registration, which I encourage all states to adopt because it's really helpful.
Let me, I'm going to get to that in just a second. I had that in my opening remarks because I think that's a key point here, in particular how it plays out with voter ID. But Mr. Call, is it correct that the 2019 active movers list from the Wisconsin Election Commission, that is the list of individuals who report on an official government transaction form, an address different from their voter registration address, included, I think, as you said, 232,000 individuals?
It was approximately 230,000, yes.
In that neighborhood. And so in Wisconsin was able to confirm about 7% or about 17,000 of those individuals were registered at their original address, correct?
That's approximately right, yes.
That's the number I have from the Wisconsin Election Commission. And so then I think the question becomes, what about the other 93% of the individuals, the overwhelming majority of the people on the 2019 original movers list? What happened to them? And from the Wisconsin Elections Commission, we were able to discover that 58% registered at a new address, which is great. They've moved, they're engaged in the process, that's appropriate. Those folks would be rational to bring off the list then. 3.6% were deemed inactive for reasons such as moving out of state, being deceased, or another reason. And then the question really comes to what's the final third? The roughly 30% or 71,000 people still on the active mover list are there because they didn't respond to a simple request for information from WEC, but there's also further indications that they've moved and they've not requested continuation of address. They've not re-registered to vote at a new address, and they did not vote in the 2020 election. WEC confirmed that no one in this list of roughly 71,000 people did vote in the 2020 election, which is to me further evidence that this might have been a list of folks that have moved. And then, Mr. Call, you argued in court to keep these 71,000 individuals on the voter rolls. And so the question becomes, what is the plan to keep the voter rolls accurate if we don't ultimately remove ineligible voters? And in the response to Mr. Aguilar asking, what is the plan? I know we can do additional follow-up, but is there a specific plan that we could do in Wisconsin to specifically remove voters that all evidence indicates have moved and should be removed from the rolls?
Yeah, so first, what we argued in court was that the Wisconsin Election Commission was not required to remove a number of voters from the rolls. And, you know, the figure that you cited, the 230,000 figure, that shrunk significantly over time for the reasons
it came down to 70,000 people total. But here, let me just move as to why I'm so concerned. HR 1, as you may know, was passed by the House and would really gut voter ID laws. And when this issue is combined in Wisconsin, it gives me great pause that we have 71,000 people on the rolls that appear to be incorrectly on the rolls by all accounts. And we're looking at gutting voter ID law with HR 1. And so in Wisconsin and states across the country, we have voter rolls that are problematic and not accurate. And at the same time, we have Nancy Pelosi and attorneys working to gut voter ID law. And further, HR 1 would create a one-size-fits-all approach. And so I'll leave it with this, because I know my time is running out, Mr. Chairman. I want it to be easy to vote and hard to cheat. And rather than working to remove key voter integrity provisions, my priority would be for us to work to find ways to really improve the confidence in our elections by working to appropriately clean up the list. And with that, I'll pause and yield back to you, Mr. Chairman.
Thank you. The ranking member yields back. This time, I will recognize Ms. Ledger Fernandez for 5 minutes.
Thank you, Mr. Chair, for holding this important hearing to hear about voting roll purges as a means of suppressing access to the ballot. And I want to really thank the witnesses for lending us your expertise and viewpoints. So the 2020 presidential election saw record numbers of Americans, including record numbers of Latinos, turn out to vote. And this was in spite of certain state actions designed to limit access to the polls, especially for Latinos and other communities of color. You know, and we see that certain states continue to pursue efforts to limit access to the ballot, including using the purging of voter rolls as an excuse. So I would note that while HAVA and federal and state laws require maintenance of the rolls, it must be non-discriminatory. So that's the issue that we are concerned about today, is how can we ensure it is non-discriminatory, especially when we have so many instances of states choosing to target Latinos and other minority voters in that process. For example, both Florida and Texas have engaged in high-profile efforts to try to remove alleged non-citizens, predominantly Latino voters, from their voting rolls. Ms. Phillips, after facing legal challenges, those two states were forced to abandon those efforts. Indeed, the Texas federal court found that the alleged problem of voter fraud was, quote, infinitesimally small. And as Ms. Lakin noted, the court further found that Texas state's actions to purge the voter rolls, which were very similar to Florida's, were exemplified, as she noted, exemplified the power of government to strike fear and anxiety and to intimidate the least powerful among us. Ms. Phillips, as a litigator in these matters, have you read these orders, the Texas LULAC v. Whitney and Garcia v. Florida, the state Secretary of State?
Yes, I have.
Mr. Chair, I seek unanimous consent to enter into the record the two documents. As noted, the first was the 11th Circuit decision holding that Florida's voter purge program violated the law, and the second was the district court order requiring that Texas officials halt the removal of the voters from the polls.
All right, without objection.
Ms. Phillips, you opined in your testimony that inaccurate voter rolls is a significant problem in America's electoral process. Do you think it's a problem if these purges remove a disproportionate number of eligible voters of color from the voter rolls? This is a yes or no question.
Absolutely no eligible voter should be removed.
Thank you. You know, contrary to what we hear and sometimes capitalized tweets of fraud and big news splashes, there's not actually evidence that there are many undocumented immigrants committing widespread voter fraud. Dr. Meredith, in your view, what's the result? What's the actual result when we have these targeted, highly publicized efforts to remove non-citizens from the voter rolls?
I think you want to think both about the direct and indirect effects that election actions will have. There are potential direct effects if an eligible person's registration gets removed, or the direct effects if an action results in a registration being removed that prevents an eligible vote from being cast. But I also think it's important to keep in mind that voters don't have complete information. You know, a lot of times I like to remind my introduction to American politics class that only about 2/3 of Americans know the name of the vice president. And so I think one concern I have when you have high profile efforts is that people don't always understand the exact actions being taken and can misconstrue actions to potentially have broader effects than they do. So for example, I've done research on voter ID laws and show that a lot of people don't understand that if they don't have their ID on the day of the election, there may be a process for them to still cast a ballot via a provisional ballot. And so I have concerns about any election policy that you don't just want to think about directly who the affected parties are, but also indirectly what the consequences might be.
Thank you, Mr. Meredith. Ms. Lakin, you noted in your written testimony that many lawsuits brought by the Public Interest Legal Foundation and other activist organizations actually focused on jurisdictions with large Latino and Black populations, and that these lawsuits were rejected. Can you share how these cases could limit voting access for minority voters?
Yes, absolutely. The problem with many of these voter roll purges that we've discussed is that in many cases, the inaccuracies in the voter rolls, the type of information that's being collected, for example, non-citizen information, are going to target, unfortunately, voters of color more frequently. When applied then in certain areas that have high populations of minority voters, you're going to end up in a situation where you're inevitably disproportionately removing voters of colors and minorities from the rolls. And that is extremely concerning.
Thank you. My time is up. I yield back. You need to unmute, Mr. Chair.
I think you're muted, Mr. Chair.
I was trying to use the space bar to unmute. I keep getting a message that it can be used as an unmute tool, but it didn't work. But anyway, thank you to the gentlelady for your questions. At this time, I'll recognize the ranking member from Illinois, Mr. Davis.
Just a quick point of personal privilege. We'll ask Jamie Fleet to send down the CAO to get your space bar fixed, Mr. Chair. They will be there momentarily, I promise.
I think I was the problem, Rodney. I confess.
It's never user error, sir. Never.
Thank you.
Hey, I really enjoy these hearings, and I've traveled the country during the last Congress talking about many of these issues. And here's the good news: the vote suppressionists that we talk about in this subcommittee, they've been doing a pretty crappy job over the last 2 election cycles, because we had historic midterm turnout. We had historic turnout in 2020, which is great, because that meant as many eligible voters in the United States were able to cast a vote for their preferred candidates. And while we may not like the outcomes of elections, that's a positive that we all ought to celebrate. And that leads me to my question. So, Ms. Phillips, thanks again for being here today. Again, with all the witnesses, give us your definition of list maintenance for the committee.
Certainly, list maintenance is ensuring that only eligible individuals are on the voter registration list.
Great. As you're aware, Section 8 of the NVRA governs the process for states to conduct list maintenance. which is critical for good election administration. Can you briefly describe the criteria and requirements that must be met in order for a state to remove a voter from its registration rolls?
Sure. Section 8 requires that list maintenance be conducted for registrants who are deceased and who have been moved. And there are certain fail-safes in there to ensure that voters are not removed unless certain criteria is met.
Great. There are many people who believe that voters are removed from their state's voter rolls solely as a result of not voting. That's not true, right?
That is not true.
And what makes a voter inactive?
It depends on state law. Oftentimes it is an indication from a number of sources that a voter has moved, a registrant has moved. For example, the National Change of Address database.
Okay. Speaking of that, can you describe the voter notification process and really the time frame that states must follow when removing inactive voters from the registration rolls according to law?
Absolutely. The problem is that this is state law specific. So it is difficult to explain every state's procedure. However, in general, there will be a notice sent to the address that is on file, and there will be steps that the registrant can take to confirm that the address is still valid. And then if the notice is returned to election officials, there are other steps that are then taken by the election official.
Okay. And some states actually do multiple notices, correct?
That's correct.
Okay. You state that in your testimony that a significant problem facing America's electoral process is the chronic inaccuracy and lack of integrity in the voter rolls that lists the individuals registered to vote in local, state, and federal elections. Your foundation has conducted extensive research into the accuracy of various state voter rolls, right?
Correct.
In fact, your foundation has sued several states for failure to maintain accurate and current voter rolls as required by federal law, correct?
That's correct. We have sued counties and state election officials.
Okay. And through your foundation's work, have you discovered state voter rolls that contain more voters registered in a jurisdiction than eligible voters that live in that jurisdiction?
Yes.
Voters registered at commercial addresses rather than residential addresses?
Yes.
What about voters registered at vacant lots?
Yes.
Deceased voters, dead voters.
Yes.
I know I'm from Illinois. I shouldn't talk about that. Non-resident voters.
I'm sorry, what do you mean by non-resident voters? Not resident of the jurisdiction?
Correct.
Yes.
So what about duplicate registrations?
Yes.
Non-citizen voters?
Non-citizen registrants, yes.
Non-citizen registrants. Okay. Well, look, I think it's great to have these discussions. We talk about vote fraud being infinitesimal, just such a small amount, it's just a little bit of fraud. You know, everything matters. Every instance of fraud matters. Remember, we did not seat a duly elected member from North Carolina's 9th district because of voter fraud and the ballot harvesting provisions that were not legal in North Carolina, but legal in California and others. There are so many processes right now in our election process that we need to delve into, but at the same time, we have to encourage the positivity of how well we've done as a country in every state across this nation in having historic voter turnout in the midterms and in the last election, the last presidential election. And I know some of my colleagues' heads might be exploding. They'll say turnout doesn't matter. Well, it did when we were figuring out, when our predecessors were figuring out what covered jurisdictions would be in the original Voting Rights Act. It mattered then, it should matter today, and we're doing things right in this country. And I thank all of our witnesses and my colleagues for being here today. I yield back.
Thank you, Mr. Davis. At this time, the chair recognizes the gentleman from Georgia, Mr. Loudermilk.
Well, thank you, Mr. Chairman. I appreciate the opportunity to be here and appreciate this hearing because voter maintenance is extremely important. And before I begin my questions, I want to reiterate that this is a top priority for every Republican on the committee, that every lawful vote be counted and that every qualified voter is able to vote safely. That is extremely important. It's the basis of our nation and our election system. The integrity of our elections should be paramount as we exercise our role on this committee to oversee the federal elections process, and that includes ensuring that voter rolls are kept up to date. One issue that is a particular concern to me and many of my colleagues, and one that I will continue to be vocal about addressing, is the propensity for poorly maintained voter rolls to undermine public confidence in election results, especially with the increased prevalence of mass mailing ballots like we saw in the 2020 election. In fact, a member of my staff received 3 primary ballots during the last election cycle. The ballots did not belong to my staff member or anyone else who lived at that address, and they had lived at that address for several years. And at the residence for the elections in the jurisdiction which he received the ballots, they did not live. Basically, he lived in DC, and these ballots came from Maryland to someone else's name. And again, he had lived at that address from way beyond the previous election. To be clear, these were not ballot applications, but live ballots. And in this scenario, if this scenario that had played out, now he took pictures of these ballots and he showed them to me, and he properly destroyed those ballots. But if this scenario plays out in states across the country, the potential for millions of ballots to be sent out indiscriminately without people requesting them and to the wrong address creates potential for fraud. And he very well easily could have filled out these 3 ballots that weren't his. I mean, he's from Georgia, lives in DC, received a Georgia ballot he requested, but received 3 ballots from Maryland he did not request, 2 other people's names. And this really brings doubt to the integrity of the election systems. Now, my questions, Ms. Phillips, your foundation brought enforcement action against states for failing to conduct comprehensive list maintenance as required under the National Voter Registration Act, as the ranking member has brought up. In your opinion, why are certain states reluctant to routinely conduct voter list maintenance?
In my opinion, the pressure has come from various interest groups not to maintain the rolls for myriad reasons. So the pressure is to do nothing. It's also at times difficult to conduct list maintenance. It requires diligence, it requires consistency, and there may be lack of training, various reasons why election officials would not conduct list maintenance.
Okay. I mean, one thing you didn't mention was funding. Have you ever encountered that maybe it's a lack of funding to do this?
Absolutely. And the problem is that having unclean rolls only makes the financial burden greater when you're mailing out pieces of mail to individuals that should not be registered to vote. So it's one of those tasks that should be a priority in order to trim budget in other places.
So you mentioned that there's pressure from outside groups, which we are fully aware of in Georgia. There's a lot of groups putting a lot of pressure on the election system on both sides. But you mentioned that they are putting a lot of pressure on some elected officials or government officials to not purge voter rolls. I know that in some cases there's threats of lawsuits, et cetera, et cetera. What impact does a state's failure to conduct their list maintenance have on the integrity of our election process?
As you mentioned, it is devastating to voter confidence. The example of one person receiving multiple ballots, especially for individuals that do not live in that location, those effects can be felt far and wide. So it is a voter confidence issue, and it also is just a misallocation of resources for these election officials that have, in many cases, very limited budgets anyway.
Well, thank you. And one last question for you. Are states required to coordinate with state or federal agencies to verify voter information when conducting their list maintenance?
No.
Okay. Turning to Ms. Laskin, you state in your testimony that accurate rolls are appropriate and necessary for election administration, and I'm glad to hear that the ACLU supports voter list maintenance. In your testimony, you highlight perceived problems with various databases available, but don't mention alternatives. If states need accurate voter registration lists, what databases or alternative measures should they use to maintain their lists?
Thank you, Representative. I think I mentioned earlier today that automatic voter registration, for example, is one solution, one assisted program that could provide assistance with maintaining accurate voter rolls, as well as ensuring that voters aren't improperly purged from the rolls. In addition, having good notice and sufficient time to voters who may have been purged from the rolls inaccurately to correct the record is absolutely critical in this regard, and is not always provided in the way that it should be provided, as is the case in Indiana, where we have sued successfully multiple times.
Well, and you know, making sure that only legal voters are the ones casting the vote is important. I could go through multiple stories of, even in this last election, people that have moved as much as a decade before started receiving ballots again from the state they moved from. And I've got numerous reports of that. And even people that are family members who called me and said, hey, I just want to let you know, I moved from state X 10 years ago. I just started getting a ballot again in this election, which was ironic that it was this election that they got the ballots that they had never, that they hadn't received since they left, which tells me it was a voter list issue. So thank you, Mr. Chairman, for this hearing. I appreciate the time, and I yield back.
I thank the gentleman. At this time, I will recognize the gentlelady from Pennsylvania, Ms. Scanlon. 5 minutes.
Thank you, Chairman Butterfield, for holding this very timely hearing.
It's not a Loudermilk 5 minutes. That's a Scanlon 5 minutes.
Can I have some of Davis's time, maybe?
Yeah, you could do a Davis time limit.
Okay.
Sure. Yes.
Over the past decade, we've seen a rise in modern day voter suppression techniques built upon a false narrative that our elections are vulnerable to widespread fraud. This false, unsubstantiated narrative has been used to justify an array of voter suppression techniques, including strict voter ID laws, restrictions on hours and places of voting, and the practice under consideration today, voter roll purges. Unlike gerrymandering, which has a long history of bipartisan abuse, these new techniques have been weaponized by one party to suppress the votes of those less likely to support that party, and to energize its own supporters by claiming without evidence that our elections are subject to widespread fraud. Of course, the members of this committee and the entire world saw the damage that can occur when national leaders spread lies about the integrity of our elections, with Exhibit A being the violent attack on the US Capitol, which occurred 4 months ago today. Pennsylvania has a robust, bipartisan election security system, including voter roll maintenance, which not only conducts secure and accurate elections twice a year, but also in the past year has managed to identify and prosecute those few bad actors who tried to commit election fraud. And it's worth noting that they were all supporters of the former president, who were inspired by his unsubstantiated claims of rampant election fraud. So we're talking about voter roll purges that have been initiated by some states, but I want to focus on efforts by groups such as Judicial Watch and the Public Interest Legal Foundation to force voter purges in areas that do not favor their candidates. In the lead up to the 2020 election, the group Judicial Watch attempted to force the state to purge hundreds of thousands of voters, but focused on the 3 counties bordering Philadelphia, 2 of which I represent, which have increasingly trended to Democratic candidates over recent years. Ms. Lakin, the ACLU intervened in the suit brought against Pennsylvania and its counties prior to the 2020 election. Can you discuss what happened in that case and address Judicial Watch's allegations about mass defects in voter roll maintenance?
Yes, absolutely. In this case, which was recently dismissed in March of 2021, there were allegations that the list maintenance process was incomplete, it was unreasonable, it was insufficient. In dismissing this case, however, the court concluded that the lawsuit was based on outdated information and data, which is subject to all the problems that we've discussed earlier. And the court also concluded that Judicial Watch based its lawsuit on, rejected the claim that just high registration rates alone should lead to an inference that counties had a list maintenance problem. And targeting districts just based on that information alone leads to is not a problem in itself. And I should just flag very, very briefly that because there is this notice and waiting process that has been highlighted by many members today and other witnesses, there is often a little bit of a lag before some voters that are to be removed are actually removed. And so that in and of itself should not be a basis for forcing jurisdictions like your own to conduct overly aggressive purges based on information that is outdated and may therefore wrongly purge and disenfranchise voters.
Would it be fair to say that this group was not seeking for a global solution to Pennsylvania's voter roll situation if it was only targeting the most Democratic districts?
I think that would be fair to say that it was targeting just the 3 districts that were included in the lawsuit.
Are you aware that having had the case dismissed just in March, 3 days ago, Judicial Watch has now tried to start the case all over again in the run-up to the 2022 elections?
I am unfortunately aware of that fact.
Unfortunately aware. So one of the things we've seen is that Judicial Watch and these other organizations bring these suits. Very expensive, aren't they?
Litigation is often extremely expensive on both ends, on everybody's part.
So it wastes valuable public resources that could go into more election security, more election availability.
I think that's a fair statement.
Okay. Is there anything we can do to reform the NDRA to prevent suits like the one that was brought here?
Yes, there are multiple ways that list maintenance can be improved, that there can be additional protections for ensuring that overly aggressive purges aren't taking place. For example, increased guardrails for using improper, unreliable, or outdated data, ensuring that there's additional checks on that information, ensuring that there's more notice that is provided for voters who may be flagged in that, and banning, for example, inaccurate proxies, for example, the failure to vote, which we have argued and have demonstrated is highly inaccurate as a trigger for removing someone for their roles. These are all different methods for ensuring that local jurisdictions and states aren't forced to conduct purges that are overly aggressive and wrongly disenfranchise thousands and thousands of voters.
Thank you. And I see that my time has expired. I did want to involve Mr. Meredith from the University of Pennsylvania in the discussion, but I'm afraid the chair will have my head. So thank you for your testimony. And I did appreciate your report.
Thank you, Ms. Scanlon, and you just got a chuckle from the staff. Thank you, thank you, thank you. The chair now recognizes himself for not more than 5 minutes. Let me just address this to Ms. Lakin. Ms. Lakin, what do you think are the most important changes that we can make to federal election laws governing state voter list maintenance practices?
Thank you for that question, Chair. The Congress can do many things. I would point to the list maintenance and transparency and notice provisions in HR 1. Those go quite a long way. In addition, there are these guardrails that I mentioned with Representative Scanlon that help to ensure that proxies that are unreliable, that are based on outdated databases are in place to ensure that voters are given security precautions before they are removed from the rolls. I'd also highlight, and this has come up in a few instances, that same-day registration. I will add that it does, in fact, provide at least some fail-safe for voters who may be erroneously purged from the rolls, who can then show up at the polls. If they are able to register and vote at that time, that is at least a fail-safe option for those voters.
Thank you. What about you, Dr. Meredith? Can you add any to this discussion?
I think one thing I would like to see done is more modernization in how people are notified when there is questions about whether they're eligible to vote or not. I think the cases that make me most concerned are when things like undelivered election mail trigger list maintenance action, which is then responded to by sending them a postcard. If the problem is that there's an issue with the mail, they're not going to get that postcard. And so I think we need to be thinking about what forms of communication we can be using beyond postcards to make sure that voters actually see the information and can act upon it in a timely way.
Thank you. Thank you for that. Let me now go to the Attorney General. Mr. Call, you've testified, I believe you said, in numerous cases to protect voters' access to the ballot. And that's a good background for the question that I need to ask you. What are the most important tools at the federal level, not the state level, but the federal level, to protect the right of the voter to exercise her franchise?
That's right, Mr. Chair. I've litigated several voting rights cases. Certainly the U.S. Constitution protections related to the right to vote are critically important, but the Voting Rights Act plays a critical role as well. Strengthening the Voting Rights Act and providing greater clarity to how Section 2 applies, I think is very useful. It's also true that we have seen states since the Shelby County ruling restrict access to voting. So restoring some sort of regime like used to be in place under Section 5 would be extremely valuable. And then rules that protect people's access to registration, like the NVRA, are also very valuable.
Attorney General, my staff tells me that you successfully defended the Wisconsin Election Commission against an effort by a conservative group to compel, it was an interest group, to compel the purging of voters in your state. What are state and local election officials, why are state and local elections officials in a better position than private interest groups to determine whether to initiate proceedings?
There are a few reasons. One is state and local officials can obtain local data, and they can find things like death notifications that when you have an outside interest group that's just using large-scale data, they can't get into the details as well. The other thing is election officials often have access to personal identifying information that is not publicly available, and so they can make a better determination often about whether two records relate to the same person or different people. And then, of course, they have experience administering our elections. They're not there with an agenda other than to administer elections fairly and effectively.
Thank you. I've got 30 seconds left, and let me conclude with Ms. Lakin. How do state voter removal programs have the potential to discriminate against minority voters?
Well, there are a number of different ways. The database inaccuracies and flawed matching protocols that we've discussed play a really big part in this. As I noted in Texas, the flawed effort there targeted naturalized citizens who are a group that, at least in Texas, was 80% of that group were Black or Latinx or of Asian origin. The same was true in the Florida purge that attempted to target, again, non-citizens, but ended up sweeping in naturalized citizens. And matching protocols, as we've talked about with Dr. Meredith, they rely on names and date of birth. They frequently disproportionately flag voters of color because their naming conventions and higher rates of similar names. These burdens also of either halting the process or getting registered in the first instance, they fall more heavily on voters of color due to structural inequalities, structural racism, a history of suppression in this country that make many of these activities much more difficult for voters to overcome. And last, I'll just, thank you.
Thank you. I think my 5 minutes has expired. Let me just thank all of the witnesses for your very valuable testimony today, and I thank the members for their questions. These have been some very insightful questions. The members of the committee may have additional questions for the witnesses, and if so, we will ask that you to respond to those in writing. The hearing record will be held open for those responses. Again, I want to thank all of the witnesses for your very valuable testimony today. Many thanks to all of you for all that you do in the voting space and the election space. You have been very valuable to this process, and I thank you for it. We will continue to have these important hearings as we seek to comply with the Supreme Court's decision of 2013. Without objection, if there's no objection, and I hear none, without objection, the Committee on House Administration stands adjourned.